I'm Special Agent in Charge Dr. David Lee. In my capacity, I have worked undercover, UC sting operations involving financial and other crimes. In that role, I have acted as a feigned accomplice, meaning I have pretended to be someone who I was not, and solicited someone else to commit a crime. This is a common tactic in sting operations, including peace officers posing as drug dealers or prostitutes and enticing others to commit crimes. You might be thinking, isn't that entrapment? I'm glad you asked. Dr. Fields has invited me to explain this concept to the class. In California, entrapment occurs if the following three circumstances existed. 1. An officer communicated with the defendant before he committed the crime with which he was charged. 2. The officer's communication included an inducement to commit the crime. And 3. The inducement was such that it would have motivated a normally law-abiding person to commit it. People v. Watson, 2000. First, the basic principles of entrapment. Because entrapment depends mainly on the probable effect of the officer's words on a basically honest person, the courts start by isolating the words at issue, after which they seek to determine whether they would have motivated a normally law-abiding person to commit the crime. In determining whether a defendant was entrapped, California courts apply what they call an objective test. This essentially means that they are interested only in what the officer actually said to the defendant before they committed the crime. People v. Capella, 1989. The California Supreme Court opined, "What we do care about is how much and what manner of persuasion, pressure, and cajoling are brought to bear by law enforcement officials to induce persons to commit crimes. The conduct of the police does not occur in a vacuum, especially in a sting operation. The court's assessment of an officer's objective conduct will inevitably be colored by, for example, whether the defendant was from the start an enthusiastic proponent of the proposed crime, or initially declined and was only gradually worn down. People v. Smith, 2003. One common misconception is that entrapment automatically results whenever an undercover officer assures them that he or she is not an officer, or if he or she took other reasonable steps to gain the suspect's confidence. But, as the California Supreme Court explained, there will be no entrapment when the official conduct is found to have gone no further than necessary to assure the suspect that he is not being set up. The police remain free to take reasonable, though restrained, steps to gain the confidence of suspects. People v. Barraza, 1979, and Calcrim 3408. Entrapment will not automatically result merely because officers initiated the contact with the defendant or because officers proposed the commission of a crime. U.S. v. Padron, 2008. In the words of the U.S. Supreme Court in U.S. v. Pullman, 2000, it is well settled that the fact that officers or employees of the government merely afford opportunities or facilities for the commission of the offenses does not defeat the prosecution. Officers may employ an undercover officer to pose as someone who is looking to commit a crime, such as a seller or buyer of drugs or stolen property, a prostitute, or a John. Entrapment may result from the actions of a police agent, someone acting on behalf of the police, as well as an officer. Sherman v. United States, 1958. As the court explained in People v. McIntyre, 1979, manipulation of a third party by law enforcement officers to procure the commission of a criminal offense by another renders the third party a government agent for purposes of the entrapment defense. Having determined what the officer said to the defendant and the context in which it was said, the courts will consider whether a normally law-abiding person would have responded by committing the crime in question. Said the court in People v. Barraza, while the inquiry must focus primarily on the conduct of the law enforcement agent, that conduct is not to be viewed in a vacuum. So who is this normally law-abiding person? In People v. Barraza, 1979, the California Supreme Court opined, "We presume that such a person would normally resist the temptation to commit a crime presented by the simple opportunity to act unlawfully." To the court, he is nothing more than an individual whose natural impulse is to say no if presented with a criminal proposal or opportunity. While he would normally resist, he could be persuaded if the inducement was sufficiently attractive. Thus, everything depends on how enticing the crime was made to appear. The same principle applies to bait car stings, a type of operation that Dr. Fields has assisted with during his time with CHP. For example, in People v. Watson, the defendant argued that a bait car operation constituted entrapment because the officers made a big production of stopping the car and arresting the driver while a group of spectators watched, then leaving the car unattended with the keys in the ignition. But the court ruled this was not entrapment because normally, law-abiding persons do not take a car not belonging to them merely because it is unlocked with the keys in the ignition and it appears they will not get caught. I'm Special Agent in Charge Dr. David Lee, and that is your lesson on entrapment.